Hi, everyone. My name is Marie Cochran. I'm an attorney with the Office of General Counsel, and I'm here today to talk about data rights. We're doing this training because GSA buys a lot of IT and a lot of other things that constitute intellectual property and come with certain legal rights. In government speak, we call them data rights. Our goal today is to help you identify the data you're buying and ensure that the government receives the rights that it needs to be able to use it the way it wants to. These are two great myths of buying data rights. I'm sure you've heard them before. One says that it's all about the clauses, and the other says that if we paid for it, we own it. The first one is something that you're likely to hear from your contracting folks, and the second one is something that you'll hear from program folks. It's a very natural kind of concept, but they happen to be wrong. And my goal today is to show you why that is and what to do about it. So why isn't it all about the clauses? Well, because that's backwards. Before we get to the clauses, we have to determine what types of data we're dealing with in our acquisition, and then we need to know what the government wants to do with it. By the way, you'll see at the bottom of your screen where it says consult your assigned counsel, which for most of you, it's not going to be me. OGC has attorneys assigned to each of your organizations, and they can guide you, and please do talk to them. Don't try to do this alone. This stuff is confusing. So we start with the basics. What is data? The FAR has a definition which is really old. It comes from the time before the internet. The DFARS is slightly less old and a lot more logical, and we'll talk about it later, but unfortunately it's only for defense acquisitions. So all of us who do civilian work, which is much of GSA, we have to live with the FAR. But for all of us, to help us navigate through this, here's how I want you to think about data. Data is what we're buying now, right now, meaning in your current acquisition. This is really our key to the FAR definition. So with that in mind, let's look at it again. What is data? The FAR tells us that data is recorded information that could be software and documentation, but it's also reports and analysis. It could be books and articles, video footage, really anything that's written or typed or recorded. It doesn't include information incidental to contract administration. That means that there are no data rights clauses for it. I have a couple of examples. And by the way, all of the examples in this presentation will be in the notes that will be posted with the slide. So, for example, a contractor's monthly status report, is that data? I've had a client ask me, well, the contractor wants to assert limited rights to the status report because they say that it contains their trade secrets because it shows how they fulfill their SLAs under the contract. Can they do that? Well, if the status report is listed in the contract as a deliverable, it means we're buying it now. It's data for those purposes. So our data rights clauses will apply to the status report. But you can, of course, and should negotiate specifics with the contractor. What about a contractor's script report? The same logic. Is it listed as a deliverable? But a contractor's invoice, for example, well, we're not buying an invoice. So that's information incidental, so it's not data. So our data rights will not cover it. And then certified cost or pricing data also is not a deliverable. It's not something we're buying. It's incidental to the contract. So there are no data rights clauses for it. You will notice that the FAR uses the same word, data, certified cost or pricing data. I don't know why they're doing it, probably just to keep us on our toes. But in our acquisitions, we usually have one or more of these three types of data: custom, commercial, or government furnished. And a procurement may include more than one type of data, and you will need more than one type of data rights clauses. It really is a spectrum. On one end, you have a micro purchase of a few software licenses, which are all commercial data. On the other end, you have a large systems integration contract, which may have all three types. It may have hot software and some enhancements to it, and some legacy stuff left over from a prior contract. So custom data is what the FAR defines as data first produced in the performance of the contract. It's something that doesn't already exist. We're buying it now. That's the point of the acquisition. They're making it for us. Not only code, it can be drawings. It can be something that they produce under a services contract. And that is very important. If your contract is for professional services or consulting services or even IT services, you have to always make sure that you understand what the output will be and how the government will need to be able to use it later or reuse it. Because otherwise, you may pay for services and not have the right to the output at the end. Pre-existing or commercial data. That's something that's out there. It's a commercial item or otherwise pre-existing data, and we're buying it now. Again, it can be software documentation, but it can be also vendor databases and reports, something like LexisNexis or Dun & Bradstreet or Gartner, or it can be these other types of things. And we need to beware of terms and conditions. If we have commercial data, chances are it comes with terms and conditions, commercial supplier agreements, ULAs, terms of service. These are usually problematic in a few areas. They can have restrictive terms, so they don't let us do what we want to do with the data. They can have illegal terms, which conflict with federal law. And they're usually designed to override our contract. But we have ways of dealing with this, and we do that through our order of precedence clauses, which we'll talk about at the end. The key takeaway here, just to flag it for you, here is that order of precedence, meaning the way you incorporate the T's and C's into your contract, is as important as the data rights clauses themselves. And then you also have all these various as-a-service offerings, software as a service, platform as a service, infrastructure as a service, cloud, hosting, etc. They are not really data. We're not buying data. We're buying access, so it's a service contract. But it comes with the same types of terms and conditions, and the same principles apply. And then finally, government furnished data. That is the type of data that exists, but it's not what we're buying now. So we're not paying someone to make it for us. We're not buying it from someone right now who is already selling it in the market. One example is content. You can have a system that you're procuring, but the data inside it, what we call the data, is really content. It comes from the government or it comes from another vendor. So for our purposes, we're not buying it now. We have several examples of that kind of scenario. For the SAM.gov is one of them, FPDSNG. When we had those systems built, they were a combination of custom and commercial. They were built on someone's commercial software package, customized for us, so custom and commercial, but the content that went inside them was government furnished. Then you have GOTS, government off the shelf, and that's data that was previously developed. So it comes from a prior acquisition, and we have full rights. The government has full rights. There are no FAR clauses for government furnished data. There is a DFARS clause in defense acquisitions, but in civilian there are no FAR clauses. But it is okay and it's a good idea to write our own custom clauses for that type of data because you do want to account for it. You do want to address ownership of it and custody. So who has rights to it? We do, and the contractor doesn't get any rights to it. And who has custody? They have to deliver it to us. Here in the little blue box on the right, there are some examples of language that you can use with government furnished data. So there was we were buying a SaaS solution, software as a service. It was built on COTS. It was customized under the previous contract. So we had a previous contract that's still running, but it's going to expire soon, and now we're working on the reprocurement. Our new solicitation says the government owns customization, but it doesn't own COTS software. The vendor sent us a letter and objected because they say under the previous contract, it said that the government owns the data populating the system, so that's government furnished, and we own interface extension, that's custom. But we don't own COTS software, or we don't own functional extensions, customizations. That's the term they created. So their proposal under the previous contract, which we incorporated into this one, into the award of the previous contract, it made a distinction between data inside the system versus interface extensions versus functional. So they wanted to be able to reuse the functional extensions, and we accepted the proposal, and that's the way it was. And the government had a license to those things during the term of the SaaS subscription. Remember that this is an annual SaaS subscription, so it expires at the end of the previous contract, and the result is that we have to pay to renew the license under the new contract. Here are some things that sometimes get confused with data rights, but they're really separate and distinct issues. Basically, data rights are about property, who owns what. All these other things are primarily issues of disclosure and access. Data security are technical issues of how to protect against unauthorized disclosure. Data privacy are legal issues about who can have authorized access to personal data under the Privacy Act and other laws. NDAs are private agreements, and FOIA is a statutory mandate that requires us to disclose information unless it's exempt. For example, the information came from a contractor, and the contractor says that disclosure will harm their commercial interests. But none of those things are really data rights. So what about our other myth? That we paid for it, we own it. We're now going to talk about issues of ownership. Most data that GSA buys is protected by law, by copyright law and trade secret law, less commonly by patent law. We don't see much of that. But under copyright law, our data is a work, and the author of a work owns it from the moment of creation, and if the author is a contractor, that means they own it. That is a feature, that's not a bug. It's public policy. The copyright clause of the U.S. Constitution tells us that we need to promote useful arts by securing exclusive rights to the creators for a limited time. So the FAR and the DFARS data rights clauses are pre-negotiated copyright licenses. That's what they are, licenses. You will also see licenses in ULAs, in commercial supplier agreements. Those are also licenses. And one minor point of semantics, a license is not a thing. You've heard people say we own these licenses, and that just keeps everybody confused. A license is permission to use. It's a right. It's a property right. So it's not a thing. We can buy licenses or hold licenses. We don't own licenses. Another law that protects data is trade secret law, and it is just what it sounds like. The creator, the owner, keeps it secret, and it gives them an advantage in the market, but they have to actually keep it secret, and that's where the NDAs come in. And you see a list of federal laws that apply to trade secrets. That's why we usually advise GSA employees not to sign NDAs, because we are already subject to those federal laws. With one exception, the GSAM prescribes an NDA for people who serve as technical evaluators in an acquisition. And then, as I mentioned, patent law, we don't see much of it, but there are clauses for it and statutes for it. So then, what's wrong with this language? Well, for example, let's say you have an IT integration contract, and your prime contractor is required to produce and use Oracle software. Now, this says all material, work product, data, and deliverables used or delivered are the property of the U.S. government. Oracle software is COTS. It is commercial data. It's legally owned by Oracle and the copyright law that we've just talked about. So this kind of language is usually wrong. So please don't use it. In fact, for the rest of our time together, I'd like you to forget the words ownership and property. Just pretend they don't exist. This is all about needs and rights. We're trying to make sure that our rights are sufficient to cover our needs. Which brings me to a couple of rules of thumb for data rights planning. You need to get enough data rights to get the job done. You need to get just enough data rights and no more, and we'll come back to that in a second. You need to know your needs, present and future. And you need to consider data rights early and often in your acquisition. Now, the least amount of data rights, that goes back again to the Constitution. It's a feature, it's not a bug. The public policy here is that when the government buys data, we want not only to get the best deal, but we also want to protect and encourage the creative industries. And data rights are their lifeblood. It's what keeps them competitive. A lot of consumer products that we all enjoy were developed under government contracts. And all our lives would be much less fun if the government had kept all the data rights to itself. So that's why the FAR tells us to balance our needs against their legitimate proprietary interests. We don't want to kill the goose that laid the golden egg. Now, sometimes we actually do need to own it all. That's an exception. It's not the rule. GSA mostly buys commercial IT, commercial services. We don't really do R&D. So for most projects, most of the time, we actually don't need to own it all. It's like the minimum viable product approach to data rights. Now we have a couple of slides on what to do at each stage of the acquisition during the procurement life cycle. So during acquisition planning, you'll be looking at your requirement. Is it a one-off? Is there a prior contract? Will there be a follow-on contract? What is your data? If this is a professional services contract, what's the final product? How sensitive is this? Does it involve national security? Or is it a contract for acquisition support services where you're worried about procurement integrity? Those are the two cases where you might want to own it all. And then you get to the solicitation. That's where you tell your story. That's where you write it up. And it is the moment of maximum government leverage in your procurement life cycle. Because you have something they want, and you have a lot of elbow room at this stage to define the data rights the way you want to. So it is important to capture all your data needs at this stage, because mistakes in this area are very difficult to fix later. For example, we had a contract to develop and deliver a system on a firm fixed price basis. And it was built on top of about 20 different COTS products. The government assumed that the contractor would buy the COTS licenses. The contractor assumed that the government would buy the COTS licenses. The solicitation contract didn't say anything, so we had a dispute. and the vendor submitted a revised proposal. They said, okay, you want us to buy COTS licenses here. And the price went up by 45%. So we rejected the proposal and we bought the licenses ourselves, and that means that we had to find the money somewhere. You can definitely think about data rights during the evaluation and award stage. It can be a factor, right? Here you will also look at how to incorporate your proposal, and you need to use caution. I'll say that several times today because that's important. For example, we had a contract for commercial item services to provide a help desk ticketing solution. And it included certain reports of performance, right? We needed a report on the number of calls, response times, resolution times, things like that. Our solicitation, our PWS, said something like, describe in detail the capabilities of the solution, including the reports. The vendor's proposal said that certain kinds of reporting were by permission at an extra charge, so they were claiming data rights. And we incorporated the proposal into the schedule, contract schedule at Section B. Now, this was a commercial item contract. It had an order of precedence clause from the FAR. The schedule and the proposal is number 1 under that list. The TWS is number 8. So as a result, the proposal overrides the solicitation, and we must pay for the reports. During performance, you can think about data rights. Marking is really important, so you really need to look at your deliverables and see if they comply. You have to document all issues. During transition out, there are a lot of issues that you can look at. They have to work with the awardee. They have to transfer sufficient rights to the awardee. They have to transfer the actual data itself, code, documentation, writing, whatever. Sometimes you can have data deletion requirements. We had a contract for commercial content, something that populates our procurement systems. And the contract included a data deletion requirement, said at the end of the contract, you have to delete all the data, which was really a big problem because it was almost physically impossible. So we had to negotiate our way out of it, and we're still fixing it. And then you have to provide for extraordinary events. Things happen. Your current contractor may be out of the picture in the future, so you have to make sure that you get the rights from them now. So how do you write the solicitation to address data rights? There are lots of ways you can do it. And the first one is in Section C. This is where you describe your requirements. And is your system, is it a website? Is it public-facing? Do you need someone else to access it other than our own employees? Does it need to be used by support contractors? Things like that. Section F is very important, especially for civilian procurements. This is where you list all actual deliverables. The idea is to map the deliverables to the specific clauses. And remember that in a large deal, you will have a mix of types of data, so you'll have several clauses that apply to each. In defense acquisitions, they have something called the CDRL, a commercial data requirements list, which does the same thing. But in civilian deals, we do this. So this is a table of items of data, deliverables. The FAR recommends this approach in Section 27.406-1. And if you see the sentence that precedes the table, it says the contractor shall deliver the deliverables listed in the table. The shall deliver is really important because it triggers the data rights clauses. It turns them on. Without it, the clauses won't work because they don't by themselves. They don't identify the data and they don't address physical possession. That must be done separately by contract. Without it, you could have a situation where you have legal rights, but the contractor has the data, and if things fall apart and the contractor won't cooperate, how do you get the data, right? So you're in a conflict situation. You can have some nuclear options to deal with it, like the claims process, but most people in that situation simply award another sole source contract to the same vendor, and we end up sole sourcing. Now, if you don't know all your data deliverables up front, you can amend the table later. You can amend it by a mod and reincorporate it back into the contract. You can use acceptance documentation. You can use different things. The point is, if at all possible, don't leave this for later. You don't want this discussion during transition out as to what rights you have to a particular item. So it happened to us as well. We had an old contract finishing up. We had a new contract in transition in, under the, and they both included Section F tables. Under the old contract, the incumbent developed some test scripts. They weren't deliverable. They weren't listed in the table. They were just to help them do their stuff. And they even gave us some of them, but not the newest version. Our incoming new contractors said, hey, I really want these. They're going to help me, right? But they weren't in the table. They weren't listed, and so we couldn't give the newest version to them. You can also do things with data rights in Section G, Section H. Section H is where your custom language goes, usually. So here's where you could put your clauses about government-furnished information and transition in, transition out, things like that. You have your FAR and DFAR clauses in Section I. You can deal with data rights in proposal submission instructions. You address compliance with data rights requirements in Section C and H. You can do a lot of things in Section M. You can use data rights as a criterion. It can be a separate factor. It can be a sub-factor, depending on what the data is. And different scenarios work best with different types of solutions. You can slice and dice it. For example, you can say things like a license that doesn't allow transfer to a federal subcomponent will be evaluated as unacceptable. So you kick them out. Or you can say licenses that allow transfer will be evaluated more favorably. So you don't kick them out, you assign strengths or weaknesses. And now we finally get to the clauses. The main point, please include them. If you don't, they will not be read back into the contract under the Christian doctrine. It's a rule of government procurement that's named after a vendor, G.L. Christian and Associates. It's from a 1963 Court of Claims case, which says that a mandatory contract clause that conveys a deeply ingrained strand of public procurement policy is considered to be included even if it's not actually in the contract. Well, data rights clauses are not like that. They're not going to be included. Here is our summary chart of the FAR data rights clauses. The basic logic is first produced versus not first produced. That's what determines your rights. And you have your default clause, and you have several different clauses for several different situations. I do recommend that every time you look at a clause, you go back and read the policy section for it, listed in the right-hand column here, because the policy sections really explain how the clauses are to be used. This is our basic default clause. It's prescribed for most situations. And the basic structure here is that both parties have rights. The contractor retains residual rights. This is why we don't own it all, usually. The contractor may withhold delivery. This is why we want a delivery requirement in Section F. The collateral agreements can override the data rights clause, so that's your ULAs and CSAs. That's why you worry about how you incorporated them into the contract. And then finally, your prime contractor has responsibilities here. They are responsible for getting enough data rights from their subcontractors. It's the job of the prime to ensure that we don't get ambushed by the sub. So the FAR defines several different types of rights that we get. These are pre-negotiated licenses. And the broadest of them is unlimited rights. It's the right to use, disclose, reproduce, create derivative works, distribute copies to the public, perform publicly and display publicly, and to have others or permit others to do so. Basically, pretty much anything we want other than selling it commercially. The contractor also has rights, and we can't distribute copies if it's software. So unlimited rights are not really what you think. They're not really unlimited. They're not ownership, but they're usually sufficient. The next category of rights under the FAR is limited and restricted. The FAR defines what that data is. So limited rights data is everything other than computer software, and then restricted computer software is self-explanatory. The specific content of the rights, what you're allowed to do with them, has to be specified in the contract, either in a collateral agreement or in one of the alternates. And here are our alternates. For most of our acquisitions, we use Alt2 and Alt3. Alt2 is for limited rights data. It gives a standard notice which says the government can reproduce and use the data internally, but we need the contractor's permission before using it for purposes of manufacture or before disclosing it outside the government. We can disclose outside the government without permission if we specify a purpose, and we list the purpose in the notice, and we have to prohibit other contractors from further use and disclosure. Alt3 is the equivalent for restricted computer software. It gives us a lot of basic rights. So if you don't have a EULA in the contract, this is usually good. You can use it on the computer for which it was acquired. You can move it between computers. You can move computer between installations. Backup and archival copies are okay. You can modify, adapt, and combine. You can allow use by support contractors. So it covers most of our bases. And you will note that EULAs, commercial supplier agreements, are usually narrower. They're much more restrictive than Alt3. This is our summary chart for the DFARS. The basic logic here is that the funding determines data rights. And again, you have your default clauses and you have your specific situations. The DFARS is much more granular and a little bit easier to follow, but it only applies to defense acquisitions. So we follow the money. Funding determines rights. If your data was paid for by the government exclusively, you get the broadest rights. You get unlimited rights. If it was paid by private money exclusively, you get a lot less. You get restricted or limited, or you get specially negotiated rights. But if it was created with mixed funding, and that's interesting, we get government purpose rights, which are less than unlimited, so they're a little bit restricted. We get them for 5 years, and then it reverts back to unlimited. The idea here is that most technical data certainly becomes obsolete after a period of time. So in 5 years, the contractor doesn't care so much that we get unlimited rights. This is how the DFARS defines unlimited rights. Again, very broad, right to use, modify, reproduce, release, etc., within or outside the government. It includes the right to publish for sale unless we're using alternate 1 and the contractor publishes first, and this is where it's different from the FAR because you can't publish, you can't sell software under the FAR. Government purpose rights, they are not a thing in civilian procurement. So if you see GPRs in a civilian proposal, you have to remove it and go back to your FAR definitions, or you can write your own custom clause, which you're allowed to do, and just make sure to follow all the rules under the FAR. But here, GPRs are the right to do all these things: use, modify, reproduce, release, perform, display, disclose. We can do it freely within the government. If we disclose outside the government, we can authorize our contractor, our recipients, to do the same, but only for government purposes. So it's any purpose within the government, it's government purpose outside, and they revert to unlimited rights after 5 years, and our recipient has to be bound by certain restrictions like an NDA or a DFARS clause. The next down under the DFARS is limited rights. It's similar to our alternate 2 under the FAR. So it's the right to use, modify, reproduce, release, perform within the government. We need the licensor's permission to release outside the government or use in manufacture or to let another party use the data. And there's an exception to the permission requirement. This is different from the FAR. Emergency repair or overhaul, release to a foreign government, and release to a government support contractor. Restricted rights under the DFARS. These are also minimum provisions that the policymakers thought we might need. So you can use with one computer at a time unless otherwise permitted by contract. You can transfer within the government with notice to the licensor. This is where your GOTS comes from. And the transfer destroys all copies because we don't want to overuse. Archival and backup copies are okay. We can modify with certain conditions, and we can permit use by service contracts or contractors or subcontractors. This is different from the FAR. It's more specific. We can diagnose and correct deficiencies in the computer program. We can combine, adapt, merge with other software. We can respond to urgent tactical situations. So the DFARS is much more oriented toward military-type situations. And there's a specific prohibition against reverse engineering, which is something the industry cares a lot about. Then we have specially negotiated rights. And we don't really have that under the FAR other than collateral agreements. Here we can specially negotiate our rights. If we don't like one of the predefined licenses, we can write our own. Except that the policy tells us we can't relinquish more than a certain amount. So our rights have to be no less than limited rights for data and no less than restricted rights for software. And now we come to our commercial T's and C's. I know that FAST gave a class last year on commercial supplier agreements and the GSOC clauses. This is just a brief refresher. There's a lot to say about this. but just the basics. Commercial software has to be acquired under commercial terms to the extent consistent with federal law or government needs. There are two issues with commercial supplier agreements. One, they often conflict with statute, regulation, and policy. There are some clauses that may potentially get you into anti-deficiency violations, and some others that just violate the Contract Disputes Act and other laws. And we've tried to address these types of problems through our GSAR clause, which we'll talk about in a second. But even separately and apart from these problems, the commercial terms may not provide sufficient rights to meet our needs. Remember, we said that they're often narrower than the rights defined in the FAR. So under a EULA, under a CSA, your license can be non-transferable, and that can torpedo your recompete. Your license can say internal use only, so you can't let support contractors use them. Your license can say you can't create derivative works. You can have all sorts of little traps, like a free eval license that converts to paid license without notice. And these types of issues we can't fix. They're very specific to each situation, so there is no GSAR clause for them. You really do need to read the T's and C's and negotiate with a vendor. But we did try to fix the first category of issues through a couple of GSAR clauses, which we adopted a few years ago. If you have a commercial item contract or task order, there's GSAR 552, 212-4, so it tracks the commercial item clause in the FAR. For other types of orders, for your GWAC orders and open market procurements that are not commercial items, you have these other two clauses. One of them is just for indemnification, and the other is for the rest of them. Normally, only a contracting officer or another authorized individual has authority to sign a commercial agreement. So if you and I click on something, normally we don't create a binding contract, but that is in a little bit of question now. There's been a really interesting and strange case come out last summer out of the Armed Services Board of Contract Appeals, the CSOF case. It's really the first case ever that says that CLICRAP agreements, CLICRAP EULAs, are binding on the government even without contracting officers' consent. So, you know, if you've ever given your phone to your toddler or your teenager and they clicked and bought a bunch of games, you would be on the hook as the owner, because the clicking creates a valid contract. For the government, the rule has always been different. You need a CO to bind the government to contractual terms, and for EULAs specifically, they need to be incorporated in the contract because we care about who gets to spend government money. So here, the Army bought translation software for use on a base in Afghanistan. The CO was somewhere else. I don't think they were co-located. And the software was shipped to Afghanistan. The contract essentially was very short. It was an SF-1449. It had a claim for 20 software licenses, and that's all. It didn't say anything else. It didn't say anything about a license agreement. They shipped the software. It came in a box with 20 CDs. It had a license there on a piece of paper, and then it had a license as a shrink wrap, so in the plastic wrapping of the CDs. And then it had a third license as a click wrap. When they started to install it, they had to click on something. All of those licenses said you can use it on one computer only, but the CO never saw the license. He didn't know it existed. No one ever told him anything about the license. They had a technical person install the software. They clicked on it. They didn't read it. And then they proceeded, as always, often enough happens, shouldn't, but happens. They proceeded to install and use way more than 20. They gave it to other contractors. They gave it to other bases. They just used it a lot more than they paid for. So there was a dispute. And the board here said, because the contract said software licenses, because you had a CLIN that had software licenses on it, that means that the CO was on inquiry notice, that there was a EULA out there somewhere. And so the government is bound by that EULA, just like a commercial company would be bound if the same thing happened in the private sector. The board provides an out. It does say that this is true unless the agreement violates federal law, but that's almost like an afterthought. They don't give us any discussion on how that would work in practice, and we know that most EULAs violate federal law, at least in some areas. So this is something to watch. We don't have a final answer on it yet. I do know that the Army has missed its appeal window to the Federal Circuit, so we'll just have to wait and see how this develops. For now, I think we're still under the rule that without a contracting officer, it's not binding on us. The last bullet on the slide, if your deal is large, if it's a large integration deal where you don't know really what you're purchasing up front, you will determine it later during the course of the contract, then you can control T's and C's through consent to purchase or request to initiate purchase. So your program manager, your core, can decline to consent to purchase until the terms have been reviewed and negotiated and we're satisfied with them. So now we talk about the order of precedence. Really, if there are two things that you take away from today's presentation, one is know your needs and your types of data, and the other is beware of the order of precedence. The best data rights clauses will not help you if they don't make it into the contract, or if there's something else that overrides them, like the contractor's proposal or commercial T's and C's. So the previous slide was the FAR. This is the GSAR. This is what we did. So we modified the FAR's order of precedence clause by moving license agreements below our own list of unenforceable clauses. So now the effect is that the GSAR clauses remove those illegal terms, the federally incompatible terms. They're lower in the order of precedence, so they will be read out of the contract. As I mentioned, they don't fix the license grant issues. You still have to read the T's and C's and understand what we're getting. GSA contract vehicles like Schedule 70 or Alliance include these GSAR clauses, and they flow down to task orders, but they don't do anything about the license grant. And then if your acquisition is an open market buy, then there is no master contract vehicle, so there's no GSAR clause anywhere, so you have to incorporate it specifically. The FAR has another order of precedence clause for those acquisitions that use the uniform contract format. We don't see that one often. We see the other one a lot more because GSA does so much commercial item buying. So here are a couple of other issues that we see. Open source software is basically commercial software with a license for anyone to change and distribute the source code. So this is by design. And so they don't tend to pose the same issues. They don't usually have indemnities. They don't usually have these illegal clauses. And you can certainly use our GSAR clauses to mitigate the risk. And you don't really have to worry about the license grant because the whole purpose of open source is that they want you to have all the rights to do what you want to do. And then public domain data. That's works that are not owned by anyone, and so they're not protected by copyright. U.S. government works under the copyright law are those that are created by federal employees as part of their job. And they're not true public domain. They're not protected by copyright within the U.S., so they're not automatically in the public domain. You need a waiver of copyright if you want them to be completely free worldwide. And if you want to contract for data and then place it into public domain, then you need specific permission from the contractor. Now this is my favorite story. This is a true story that brings together pretty much everything that we've talked about today. It was a project where basically everything that could go wrong with data rights went wrong. And now that everyone who was involved is pretty much gone, I can tell you that this was FPDS-NG. So they awarded a contract in 2003 to build it. And it was awarded as a proto-SAS. It was really before SAS was defined as a concept very much, and so they wanted it to be contractor-owned, contractor-operated, because they wanted to cut down costs, the cost of ownership. They didn't really think of data rights much except in case of premature termination, and this one didn't terminate prematurely. There was no delivery requirement. There was no list of deliverables. So then the contract expires. They want to award a maintenance and enhancement contract, and they ended up sole sourcing to the same contractor. So they bought themselves a few more years. But again, no clauses in the second contract. They had some in the solicitation, but somehow the contract, when it was awarded, the final contract didn't have any clauses in it. They had a transition task which mentioned data, but really sort of not in the right way, and it was optional as well. The transition task said something like, provide information about existing data and licenses. And that's very different from we give you, you give us this right now. So by the time that contract was ending, they brought OGC in. And at that point, the contractor was under a DOJ investigation for false claims, and they were preparing to file bankruptcy. So we really had to scramble to buy the system before they went out of business. And they had nothing to lose, and they had no reason to be really cooperative. So we looked in, and it really was a mess. You had 17 COTS products. You have issues of non-transferable COTS, right? Because they bought it as a private company. They didn't assign it to the government, so the government couldn't hold that license. We had to buy it again. Some of the products were not even offered anymore. They were so old, so we had to buy some sort of replacement. We had overused a number of them, so we had to pay for that. So we really ended up paying twice on that contract. We paid $9 million to the contractor, and we paid almost as much or more to vendors of these COTS. And here are some helpful resources for you on data rights. The first two are really good. The first one is old, but it really is still very good. It helps navigate all these issues. They are both DoD publications, but they can help you in planning your civilian deals as well. And then here are some basic legal references for what we've talked about. And this concludes our data rights presentation. Thank you for listening.
Okay, thank you very much, Marie. That was a lot of great nuggets, information that we can use as we put contracts in place. and accept these software agreements. So what I would like to do is to remind everyone to enter their name if they haven't done so, or their email address in the attendance roster at the top of your screen. And then we have just a few minutes to address just a few questions that we received. While you're entering your name, if we're unable to get to all the questions at this time, we will put together a FAQ and send that information out to everyone. So two things will happen after the training. You will receive a survey that you will need to complete in order to earn 1 CLP. And then you will, in a couple of days, you will receive a copy of the slide deck, a copy of the recording, and any FAQs, any questions that were addressed today or offline, we'll put together and send them out to you as well. Okay, so I'll hand this over to my colleague, Talisha, where she'll address the first question, and Ms. Cochran will address the answer.
First question. I contract with a vendor to provide me with the top 10 candidates for some IT staffing. Do I own the entire survey list, the top 10, both, or none?
The answer is you have to define it in your contract. What would you like to not own, right? You have to have a license to these and then specify it in the contract.
Okay. Next question. I contract with a recruiting firm to capture resumes in a database for potential hiring purposes. Do I own the resume data?
Again, probably not. We don't own it, but you have to specify your rights in the contract. What do you need to be able to do with those resumes?
Okay. Next question. I have an old payroll system with time and attendance, and I hire a new vendor to create a new payroll system. I want to transition the employee data to the new vendor. Do I own the data rights to do so?
What is the employee data? Is it government furnished? Where did it come from? If it's government furnished, then yes, it's yours, and you will provide it to the new contract as GFI. But again, the specifics will be in your contract.
Okay. Last question. Second to last question. If the government holds unlimited data rights, can they use the data software source code for a bidder's technical library? The purpose would be to allow a recompete of an agile development program, government paid for the previous development.
So if you paid for the development of this source code, this is data first created under the previous contract, right, or under this contract, if there is no EULA that overrides that and you have unlimited rights, then yes, you can use, display, etc., and you can allow others to do so. You can't sell, but you can do pretty much anything else with it.
Okay. Does OGC have a set of canned data rights language the COs could incorporate straight into solicitations and contracts? And second part, while many procurements may require specifically tailored language, it sounds like some procurements could benefit from the standard boilerplate.
We don't have standard boilerplate simply because there are so many variables. There are standard types of acquisitions, but even there's so many variables. What data is involved, what your future plans are. So we don't have canned language, but we are happy to advise you. And over time, if you keep doing the same kind of acquisitions, you will sort of develop a feel for how these things are written. But do consult your legal counsel.
Okay. We're running a little short on time. So what I would like to do is I'll leave this meeting space open for a few more minutes for anyone that still has some questions, and we'll take those questions offline. And as I stated, we will put those questions together, provide responses to those questions, and get those responses out to everyone that attended the training. Again, I want to thank you for attending our training today. We look forward for you to attend future trainings this year. We have another training next week, which is on social economic from the from OSBU. So please, if you haven't done so, please register for that training as well. Again, thank you, and we'll talk to you again soon.